Thank you so much. I hope everyone can hear me now properly.
Yes.
So
But
now I'll just share my screen.
sure.
Okay, here we are.
Yes.
Yeah. Now, thank you once again for your kind words. I'm really honored to be here. And this topic, will, how and why is a will important, is really an apt topic for me because, like it was just said just now, out of everyone present over here, just give me a moment. I think there's something wrong with my screen sharing.
No, we can
Ah,
see
yes.
this first slide.
I
Yes, yeah.
got it. Yes, yes. So, out of everyone present here, like you just told a few minutes ago, I have been the one who has actually come very close to death. So, I can honestly say that, life is like a roller coaster. You get no notice. 1 minute you're here, you're enjoying your life, and next minute there's nothing. Now, let me tell you my story. You already heard much of it. But here I am before you with a second chance in life. I did not even get to go home from my college that day when I was diagnosed with a tumor. It was just my accident, actually. I just had gone for an eye checkup, and that checkup actually turned out to be an indication of a tumor. And I could not even, do simple acts like touch my nose, and it was going all haywire because I had no coordination. So from there to here, it has been a roller coaster ride. So, my advice to you is that live life to the fullest, but at the same time, prepare yourself. Make a will now. You all have got that chance. Now, actually, the topic for today is about will, but I want to say that where there is a will, I can honestly say there are lots of relatives. And I can really say that because I've seen this happening in my life. Now, do you see the picture on the right side of your screen? It is a
Yes.
stamp paper. Okay. Now, where have you seen this? Can you choose one of the following? In the movies? Yes, in the movies. In every movie, you have a Vasiyatnama which is made on stamp paper. I really do not know the reason why they do that. I don't know which lawyer they really consult because a will is not to be made on stamp paper. So then, what is it about a will? Okay, now we have all heard about a will. Everyone present over here has heard about a will, right? Now, um, does anyone know what it is for? Can you please raise your hand if you know generally what it is for? Can you raise your hand if you know? Yes, thank you. So wonderful. Now, I think most of you seem to know. Now, a will is a legal document which spells out your wishes after you die. Now, do you want to know when is the right time to make a will? Do you want to know when you should make a will? I would say now, right now is the right time to make a will. Why? Because you never know when you're going to die. Now, let me tell you one more story. It's a very recent story, it's a real story. One of my clients was in his 50s. One evening, about 4 months ago, when COVID was raging on, he felt a slight itch in his throat. So he went to the doctor. A doctor at that time, the testing was in great vogue. So doctor said, go to the lab, do a COVID test. So he went to the lab at 8 p.m. The results were to be out at 8 o'clock in the morning. At 3 o'clock in the morning, 3:27 a.m. to be exact, he got up, feeling very restless, breathless, and by 4 a.m. he was gone, passed away. No second chance. This is how uncertain life is. One very wise man, his name is Franklin Roosevelt, American president. He said that in life there are only two things that are certain. One is death, and the other are taxes. So
Access.
taxes you have to keep paying, and that is a certainty. Okay. Now, do I have your permission to go ahead? Please. Thank you.
Yeah.
Thank you. Thank you so much. Now, tell me, how many of you believe that peace of mind is the most essential thing in life? Put your hands up, please. Thank you. So, and how many of you know how to create that peace of mind? Can you again put your hands up? Well, I didn't have so many show of hands, but fine, let's go on. So, today I am going to tell you how to reach that peace of mind, and I'm going to tell you the importance of making a will. Do you want to really hear this? Wonderful. Now, you will wonder, for each of you will wonder, what is in it for me? Why should I be sitting here listening to Dr. Pallavi Divekar and raising my hand every now and then? Why? I'll tell you why. By the end of this talk today, I am going to tell you how to make a will. Because do you know that even a handwritten will is a valid will? You can just write on plain piece of paper. There are no formalities. I will also be telling you whether you need to register that will, which is the question on everyone's minds. And I will also be taking in your questions. Whatever questions you have for me, I'll be happy to answer them. But first, let me start by asking you a couple of questions, maybe three questions. Now, have you all not worked very hard in your life to put aside a little bit of money? Correct? Am I not right? Right? Now, is it not your wish that your children get the benefit of this hard work? Yes or no? You can even open up your mics and answer. No problem. Also, the most important thing is everyone, I think everyone wants to avoid legal disputes, especially legal disputes amongst your family members, and stop strife and discontent in your family. Correct? So these are things which everyone wants to ensure. Now, let me tell you, you can ensure all these things by making a simple will. Now, a will is a document that sets out your wishes and distributes your property. If you die without a will, your wishes will simply not be carried out. So, what are the advantages of a will? Now, I can say savings. When you make a will, or rather, when you do not make a will, your heirs may be forced to spend additional time, energy, emotional energy to settle all your affairs after you're gone. Again, if you fail to make a will, you will be you will be leaving all these decisions, these important decisions regarding your assets, in the hands of some third person, some authorities, court, lawyers, etc., which you do not want. That is definitely not your choice. In fact, that should be a last resort. Decisions regarding your assets should be made by you, and that's that. Now, uh, see, if you leave your affairs in a disarray, it is bound to cause strife in your life. Please just take a moment to realize one thing, that you may be seeing people in your life who keep visiting court. They have so many matters here and there, they keep going to court. Now, most of these times, if you really see with intensity or uh, with concentration, you will realize that most of these people are there. They keep going to court because somewhere along the way, their documentation has a problem. They have not been able to make clear documents. It may be anything. It may be documents regarding your property, documents maybe like a will, etc. But that is the bottom line. So make this one document, stop this strife. Now, there's a misconception that people seem to think, and I know many people who come to me and say the same thing, that will is only for wealthy people, or will is for those people who have got complicated assets, complicated investments, and only those people should be making a will. That's not true. Not true at all. Anyone can make a will. Anyone. Even if you have a single child, please make a will. Why? Because it will protect your spouse, if not anyone else. Please understand that you can give a life interest to your spouse, your husband, or your wife till their death. And in this manner, you can protect them. Tomorrow, your son, daughter, daughter in law, son in law will not be in a position to throw them out. Now, you can also be clear about who you want to give your assets to, because after all, it is your hard-earned money. The converse is also true. You can actually keep your assets out of the hands of people you do not want them to have, like say estranged relatives, etc. For example, I'll give you an example where I knew somebody who was not talking to this particular nephew. This person was a bachelor. The person I'm talking about was a bachelor. And he was not talking to his particular nephew for 20 long years. But he did not make a will. And the result of that was that after his death, the property went to this very same person whom he did not talk to him for 20 years. And this person got all his wealth. Now that's a very sad state of affairs, isn't it? The fourth thing, you can also identify, who you would want to care for your minor children. For example, there may be some cases where there are special children involved. There are mentally challenged children, there are disabled children, and you have the full responsibility of those children after you. And you do not know what will happen to them after you. Now, please understand that without a will, the court will be appointing some guardian and will decide where these children can go. If you make a will, you can make a provision, for those particular children. For example, I will tell you that there was a family who had a mentally challenged son. Now they made a will in such a way that there was an arrangement in that will that after their death, the husband and wife, their son would go to the Aurobindo ashram, which is in Pondicherry. And even today, their son is living in the Aurobindo ashram. He is being looked after, and they had this arrangement with the ashram. Now, this is how he's taken care of, and this can be done by making a will. Now, the most important thing, can anyone tell me how often you can make a will? Can anyone tell me? You can open your mic and tell me. No problem.
As many times you want.
Correct. Absolutely correct. You can make a will howsoever many times as you want. There is no restriction. So technically, you can wake up every morning and make a will. So the next logical question is that if you make so many wills, if you make multiple wills, then which is the correct will?
The last one.
Correct. The last will before a person's death is the legally valid will and it is enforceable in law. Okay. Now let's go to the topic which all of us have been waiting for. How to make a will. You see, like I said before, it is not important that a will have a prescribed format. In fact, a will can have no format at all. It's perfectly fine. It's perfectly valid. But then what happens is, while there is no prescribed form, it is always a good practice to follow a certain pattern so that everything necessary by law is included, making your will simpler, more solid, compact, and most important, difficult to contest. So then you should be looking at these basic things. Now there's one more aspect to it. Now in these times, especially now during this COVID phase that we're going through, many of you may not be very happy going to a solicitor, going outside your house. I can give you an easy way which you can do a will right where you're sitting. All you do is type out an email to your solicitor or advocate and list out all your properties and assets. Make a detailed list. Write your assets, your bank accounts, your insurance details, your investments. Mention all of them. Second, name an executor. Executor is someone you can trust, someone who will carry out your wishes the way you want him to. Now, if you do not find someone you can entirely trust, don't worry, no problem. Because ultimately, the heirs and the beneficiaries are bound to see that the property is distributed as per your wishes if they want something out of your will. Now, you also make a list of whom you want to bequeath your wealth to. So, on the one hand, you make a list of assets, investments, properties, etc. On the other hand, you make a list of who you want to give what to. Now, even if you don't want to give somebody something, like you want to leave somebody out of that will, give a short reason why you want to leave that person out. Not a long story, not a huge paragraph, just a very short two-line reason. It always helps. Okay. Now, after you do this, you send an email to your solicitor. Your solicitor will draft that will in the proper legal format the way it is to save you ambiguities because it has to be in a clear, precise language where there are no latent ambiguities which will cause a problem later on. You see, then in after that, the will be sent to you You take a print of that will, preferably on green paper, and then the most important thing is you sign it before two witnesses, two persons, so that they get to attest to the fact that they saw you, the testator, actually sign it. Now, just remember just a few tips while we are on this topic. Your witnesses don't need to read the will. They don't need to read the will because all that they're doing over there is they are signing. I've seen the testator, this person, sign the will, and therefore I'm signing the will. So they don't need to read the will. They just need to attest the fact that you have signed it in their presence. Secondly, the beneficiaries in the will need not or should not, rather, let me put it this, should not, cannot be the attesting witnesses. So if you're giving it to XYZ people, please see that XYZ do not become your witnesses. Get some third persons, take that effort and make them the attesting witnesses. Now, also important is that you initial every page, date every page, and write the place where you have made the will. It gives us a certain amount of clarity in the will. So you will write the initial, the date, the place, and your witnesses will also sign it on the side. So all three of you have done that. Okay. Now, also look for some of the other corrections in the will. This is what I always emphasize to my clients. Any small typographical error on the page or the but, why, those sort of errors, cancel it, initial it, make the witnesses also initial it. Why? It just shows that you have paid attention. Not only are you of sound mind, but you have also read your own will. It just shows that this sort of a will is solid and difficult to contest. And last but not the least, what good is the best of wills if you do not keep it in a place where somebody can find it? So keep the will carefully. Keep it in the bank locker, keep it with your solicitor. Make sure your family members know, or rather executors know where your will is kept. Don't keep it in some secret place where nobody can find it and then they accuse something else. That is very important. These are very small, simple, everyday tips, but sometimes they need to be told because these things need to be addressed. Now, if all this is very difficult for you, just go to your visit your advocate or solicitor. He or she will do the needful. There's no difficulty. Now, I have written many articles on these small topics. You can even go to my blog. It's called The Lawyer Speaks. I've written about wills, registrations, partnership disputes, all other topics also. Now, a lot of people ask me about registration. Is registration necessary? Is registration compulsory? Well, I can answer it this way, that registration is a tool which is given by the legislature. It's a tool which a law has provided. It is not compulsory, but it is always good if you register. Why? I will tell you, because once a will is registered, it means it is kept in the safe custody of the registrar in the registry. So it cannot be destroyed, it cannot be mutilated, it cannot be damaged, or it cannot be stolen. It is also a very strong legal evidence that the proper parties had appeared before the registering authority or some authority appointed by the government, an officer, and attested the same, this will. So if your will is lost and suppose the will is registered, then you can always go to the registrar and he can provide you with a certified copy. You need not look here and there and panic. Also, it is the process of registration is not very difficult. It's a very simple process. It gets done in 1 hour. It is at Old Customs House. You can go there. The process of registration begins when a will is deposited with the registrar. So what the registrar will do is he will scrutinize your will. He will point out if there are any mistakes. He will make the entry in his register. He will write the year, the month, the day, who had come, the witnesses, even the hour he will write. And then he will issue you what is called a certified copy that is given to a testator. Now, the question which might come to your mind is, now suppose, I register this will, I go through this whole process, and suppose then I want to change my will because I can get up every morning and change the will. So suppose I do that, then what do I do? You have a remedy. You can just go to registrar, give the proper reason in writing why you want to change this will, a short reason, no long story, a short reason, and you can withdraw that will and you can make your next will. Right? So it is all very simple. There's nothing difficult about it. Now, what I've done is I've tried to introduce some legal jargon, because when you're talking about wills, you will naturally be talking about things like intestate. Who's an intestate person? Is somebody who dies without a will. Then a testator is somebody who makes a will and executes a will. Then a beneficiary is obviously somebody who is getting the benefit of that will. Then executor, like I said, has to be a tried and tested, trustworthy person who will do what you want him to do. There can be multiple executors. You can say so and so is an executor, failing him so and so, failing him so and so, and you can have up to 4 executors of a will. Then a probate. A probate is a necessary part. It is a legal process which happens after you pass away, and it is for the court which gives the authority, a stamp of authority, so to say, on the will, so that your executor can administrate your estate. And administration, or rather administrator, is something, if you haven't left behind a will, instead of an executor, he is called an administrator. So this is it. So the long and short of this entire, of course, I've forgot, missed out on this codicil. Codicil is also a legal document, which is suppose something gets left out in your will, and you don't want to make the will all over again. So you make a short addendum to the will, and it is called codicil. And everything that has to be done for the will has to be done for the codicil. So it is not really a shortcut. It is just a alternate way of going about it. Now, the long and short of this entire lecture, if I may say so, and the takeaway from today is this: please make a good will, make a proper will, because you see, you cannot come back from the dead and correct your mistakes. So, my endeavor today was to point out that these are the short, simple steps that you can make, and then be at peace. Just make a good will, be at peace. And of course, you can keep updating your will if you have, a substantial changes in your assets or life, or some, like you may sell off a huge property, you may want to record that. You may buy another property, you may want to record that. Or there's a residuary clause in the will. If you do not make those changes, it is a residuary clause, and there's also somebody called residuary legatee, whom you can say the rest residuary goes to so and so person. That can also be taken care of. So this is in short outline of how you go about making a will. I'll be very happy to take your questions. Thank you so much for being so patient.
There are some questions in the chat box. Can you want to access it and
Yes,
answer them?
I'll just access the chat box. Just give me a moment.
Yeah.
And,
Should I read out?
should beneficiaries become an executor? The question is, I have addressed this point directly. Beneficiaries should be an executor to an extent where you can trust them, or you feel that they're capable of managing the entire this thing. Because sometimes there are children who are quite young, who may not be able to, manage all the some people in your family. So you can take your call on that, and you can name them executors. But yes, beneficiaries technically can become an executor. There's no difficulty about it.
Madam, what
Another
about
question:
the
do
HUF?
witnesses have to go for registration of will? Do the witnesses
Yes,
also
yes,
have to
yes,
go?
yes.
Yes, have to.
So for registration of will, the whole process needs to be replicated. But what happens is, more often than not, is suppose you don't find a witness at that time. So witnesses are not somebody who's it can be anybody. It can be people from the office of the registrar also. Your own registration clerk who goes with you can be a witness, because this is a supplemental will. That way, it is just to show that you have been to the registrar and they have been witness to that fact. So yes, you need to visit the registrar.
Yeah, President, you are asking a question. President, what's you?
Yeah. What about the HUF properties? Because that cannot be individual properties. So how? Because even
So
HUF there is no co something also. The second name
correct,
also is not there in bank accounts.
correct. So what happens is, there are two parts to it: ancestral properties and HUF properties. As far as ancestral properties go, you can will away your share in ancestral properties. What is your direct share? Nobody else's. That way. And as far as HUF goes, HUF is another entity altogether. HUF is another entity altogether. So you can say your share in the HUF. That can be willed again, just like
Okay,
ancestral
fine.
property. So you can make a clear provision like that.
A joint will is better.
A joint, there are joint wills and there are mutual wills. Joint wills are a bit complicated, so what happens is when a person dies in a joint will, all those that property goes to the person with whom you have a joint with. So unless you want that sort of arrangement, it does not make sense to have a joint will. What you can do is have a will where you give it like a mutual. So if you're husband and wife, you can say that my wife gets everything. That's the wife who's making it can say my husband will get everything. So that way is a much better way instead of making a joint will. But yes, you can technically, you can legally, you can make a joint will. Yes, that is one type of will. So, can you challenge a will in the court of law? Yes, yes, of course. That is why the whole will thing is drawn out. When you make a will and a legally correct will, the whole purpose of the will is so as not to allow it to be contested in court. If you make a good and proper will, what can the contest be on? It can be either that you made the will by fraud, by coercion, by undue influence, or some such parameters which are there in the Contract Act. Now, if you make a good and proper will, which is difficult to contest, when the person can with a sound mind, he has written very clearly in his will what he has, what he wants to give, why he is not giving somebody who has not left something to. Even if that line is there, that person who's contesting will not have any ground to stand on, any leg to stand on in the court of law even. So yes, so technically you can challenge a court of the will in the court of law, but the endeavor is to see that the will does not get challenged, because I'm the kind of advocate who does not want litigation, and I will go out of my way to see that litigation is prevented at the first instance, rather than keep having two litigations instead of one, three instead of two, and so on and so forth. Right. If there's one question, if after registration of my will, I can change it, but unfortunately can't change the registration office, which is held valid. You need not register the will at all. So if you make a will and keep it at home, it is a valid will. There is no question of registration. There's no need for registration.
No, what she says is if a will is registered and later I make another will which is not registered, so which is the valid will? Registered will or the last will which I have made?
The last will.
Last will, the
Last
registration.
will is it.
Okay.
Yes. But then there's somebody challenges it, because registration is a strong legal evidence that you
Okay.
have made a proper will versus a will which is made at home. So the person who's propounding that will, the second will which is made at home, will have the task really to show that yes, this is the will which so and so made, because it was the last will, and this will is more appropriate than the will which is registered. That will be that person's onus. Then a question is come, if a will is challenged in court of law and the witnesses are not alive, does it change the validity of that will? No, it does not change the validity of the will. It's okay. But a good practice again would be when you select your witnesses, in the normal course, we always tell our clients, please bring witnesses who are younger than you, because there's a likelihood that they'll outlive you. Of course, nowadays there's no guarantee, like there's no guarantee, but generally that is the thing. Because if the witnesses are alive, then they can come to court and stand in the box and give this thing. If they're not alive, then the person who's the beneficiary or who's the propounder of the will, the onus lies on him to show that, yes, this is a valid will, so what if the witnesses are not alive? That way, all other parameters are valid. Is there any question that I've left out?
In HUF will, there's one question on Arvind Shah.
Yes.
In HUF will, if wife expires and another query, if wife gets divorced, then how treatment of that HUF is treated? I'm not too sure.
No, so like HUF, like I said, you can give your share. Then these are two questions actually. So in the
Yes.
HUF, you can give your share of the property of the HUF to whoever you want to. Now, as far as divorce is concerned, so what happens? That's a very interesting question, because when the wife gets divorced, she no longer remains your legal heir. So actually, in English law, there was actually this thing that marriage, even in Parsi law, even today, there is a provision that after you get married, everything changes, and therefore you must make a will all over again.
Right.
So a divorced wife is no longer your legal heir. So please change the will. Otherwise, if those parts of the property which are given to her and they are in the will, they become invalid. just because the name is there in the will, because at that time when you made the will, you were married to her. Later on, subsequently became divorced. I mean, you got divorced, so that part of the will remains invalid. So it becomes complicated. So after divorce, it is always, better, prudent to change the will.
Another interesting question: can a will without an executor be valid?
Yes, of course.
It's a valid will.
Yes, yes. The will need not have an executor. The only difference would be that instead of a probate, you file for letters of administration. It's
Okay.
another process. It's parallel to a probate. So with as an executor, you file for probate. If you do not have an executor, you file for letters of administration.
Administrator.
Yes, with a
I
will
have a
annexed.
question.
Yes,
I
please.
have a question.
Please.
If after death, if the is the executor required when any of that property has to be sold?
No, no, no. Executor's job is only with the will. So after the probate is got and the executor has done his job, the executor exits. So when the property has to be sold by the beneficiary or legatee, the executor has got nothing to do with it. That is that person's property. That role is limited to the point where the executor approaches the court, takes the property in hand, distributes it, and that's it. After that, he has no role to play. He has to quietly exit. He cannot forever be the executor and have some sort of control on the assets and all.
Exactly. This
No,
this is important when we all have a child staying out of India and child staying here.
correct.
So if you make the person staying out of India executor, it becomes a problem if they have
Correct.
to be there
Correct.
when you sell it.
So, no, so when you sell it, it means the child who's in India wants to sell it, and suppose the property is given to that person, the executor has no role to play. In any event, it is very difficult to be an executor and execute the property from out of India. So the executor
Exactly.
will have to resign, and the will have to be administered by the court of law as though it were a will without an executor. So that process is there.
Okay. All right. Thank you.
Thank you.
Do you need a health certificate before making a will?
So the common practice is to get a doctor's certificate at the end of the will, or have a letter of the doctor attached to the will. Now that is an additional measure, just like you treat a registration, you treat this thing. So when you open the will, the first line is "I am of sound mental health." A doctor's certificate only shows that particular line. It endorses that line. Yes, when the person made a will, I have examined him and I found him to be of sound mental health. It just corroborates that, adds to it. It doesn't by itself mean anything too much. But it is prudent to take it, because sometimes what happens is that, at the end of your life, you may be of very frail health. At that time, the endeavor will be to show that yes, even though my health is failing and I cannot walk, or I cannot move too much, I'm of sound mental health, and my doctor is here to prove that. So people take that doctor's certificate, attach it, or sometimes you just write 2 lines and the doctor signs it and puts a stamp and registration number, so that tomorrow, if the will is challenged, then that doctor can be called as a witness, and doctor will have to say on the stand that yes, I examined the person at the last stage and I found him to be of good mental health.
Can the beneficiary's wife or spouse witness the will?
Can a beneficiary's spouse?
Spouse witness the will.
The spouse can witness, but as a prudent distinct, the person who's making a will, his spouse should not be the witness. As a
Beneficiary
prudent,
spouse can be witness.
yes, yes, because that becomes a third person altogether.
Right.
So a witness is okay, I feel, if doctor dies, then it doesn't matter. It doesn't matter. If the doctor dies, it is up to the person who's propounding that will to then show that the person who's made the will is of sound mental health. It is okay.
Can a
Can
will be
will
granted?
in
Sorry.
favor of a third party or not? Of course, a will can be by will you can give a property to anybody. There was an old English case where the property was given to a dog, and that was held to be a valid will, because it can be given to anybody. It is the person's wish, and so anybody can get the will.
What is a transfer deed?
Transfer deed is an agreement. It's actually a writing by which you transfer some property, mostly immovable property. So your Sale deed is a transfer deed, indenture is a transfer deed, a sale agreement is a transfer deed. These are transfer deeds. Even a gift deed by which you transfer can be read as a transfer deed. It is not a will. By will you cannot, it is not the actual thing which you transfer. It is a means to that.
Like after probate, you are asked to get a transfer deed or something.
Correct. So after probate, all the properties are sorted out. Then you can start actually doing what you want with the property. You can sell the property. You can transfer it to your name. That is where the transfer deed might come. You know, that way. So sometimes there are societies in which the flats are held. So then you carry out the process of transferring the flat in your name. Uh, pursuant to the probate. This is where the transfer thing comes into question.
Dr. Pallavi, one of the misgivings among the people is that once you nominate your flat in a cooperative society, then there is no need to make a will because nominee will inherit the property and become a legal owner.
Correct.
But which is far
that
from.
is now what the Supreme Court has held, that you need not, the societies, earlier what they used to do, they used to insist that you get a probate or letters of administration or get something from the court. That is what the society used to write. Now, to make life easier for societies, banks, insurance companies, the law is very clear, and even it's written in the section 45ZA that a nominee for the bank, for the outsider, like a society or a bank or insurance company, they simply have to look at the nominee and say that, okay, fine, there's a nominee in place, I'm just going to transfer it. Now, whether that person has got a, legal right, is an heir, beneficiary, that is that person's problem. For the society, it is of no concern. So, it's not, earlier societies say that, oh, I don't want to be involved in this litigation, because invariably societies used to be a party. And in every litigation, there used to be a party, and they have to spend money on that. So society has to be very careful. No, you go to the court, get me some court order, we'll transfer. That is to be the thing. Now the law itself has given a sort of a way out for the societies. Okay, no, don't worry about all these things. There's a nominee in place. Just put the nominee as the owner, and then the beneficiaries will see what they have to do.
But the nominee doesn't get the title.
Nominee does not get the title. He just on paper, the society can transfer, but the
So
heir
there
can
again-
always challenge. Heir can always challenge. That you
So
are
there
just
again, the
nominee.
will plays the important role. If will is
Correct.
there, then
Yes.
property. And
Yes, there can be no substitute.
Right.
Nomination cannot be a substitute. That way. How much time does it take for a will to get probated? Normally, what they say is, we always, with caution, we tell the clients that it takes about 8 months to 1 year. Of course, we can hasten the process. How can we hasten the process? If, for example, everything is in place, there is no contest, you can easily get the probate, because everybody, there will be consent affidavits given, and everybody's on board, to help with the process of probate and push it forward. But in certain cases, there's a lot of litigation which goes. Somebody challenges the will, then somebody else, does something else with the property. So then that whole litigation goes on and on. So there's no outer limit. But yes, 6 months, 8 months, 1 year are the stages that you can get this thing done. Is a will better than a revocable trust? So what happens is that these are two different things. In a will, people make trusts. So if you have property and you want to see that property is protected. Let's say that you have minor children and you want them not to have the property at a very early age. So in that will itself, you can make a trust and say that when my child reaches the age of 25, then so and so property can be given to me. So it becomes like a will becomes a trust. So these are two concepts are rolled into one, will and trust.
Okay, I think we are running out of questions. President, over to you again.
See, my son and many people, the children have gone abroad. They are abroad.
Yes.
So we are all alone here. So if we make a will for them as a beneficiary, how does it work?
No, if you make a will for them as a beneficiary,
Yes.
yes, it can definitely. So there are many cases where the children are abroad, where the beneficiaries are abroad, but they do come to India to take whatever is theirs and go away. So while the process, you can name an executor who's over here. So the executor will pave the ground for your children to come and enjoy the benefits of your will, of your estate property. That can be done.